If you are 72 years old and you have lived in your home for 31 years, you paid off the mortgage, you raised your children inside those walls, and every single room carries a piece of your life, then what I am about to share with you matters more than almost anything else you will hear this year. Picture this. One ordinary morning, you suffer a stroke. You survive, but you cannot speak. You cannot write your name. You cannot make a single decision. Your daughter rushes to the bank to pay your property taxes before the deadline hits. She walks up to the counter. She gives them your name, and the person behind that counter looks at her and says, "We are sorry. You have no legal authority over this account. Your daughter cannot pay your bills. She cannot touch your accounts. She cannot sell your home, refinance it, or even arrange basic maintenance on it. Everything is completely frozen, and the bills keep arriving. This is not something that happens to other people." According to the Consumer Financial Protection Bureau, this exact situation unfolds for families across America every single day because 5 straightforward documents were never signed, never filed, never put in place. My name is Jun, and I am a senior policy analyst who specializes in retirement finance, Social Security rules, and the legal protections that exist specifically for people over the age of 60. Today, I am going to walk you through the 5 most important documents every homeowner over 60 must have in place before a crisis arrives. These are not opinions I formed on my own. They are not rumors circulating online. Every fact I am about to share with you comes directly from official government sources: the Consumer Financial Protection Bureau, Medicare.gov, the IRS, the Social Security Administration, and verified AARP research. And here is why I need you to stay through this entire video. There is a hidden tax trap buried inside document number 5 that can cost your children hundreds of thousands of dollars in capital gains taxes. It all comes down to one single decision you make about your home while you are still alive and able to make it. Most people have never been told this trap exists. By the time this video ends, you will know exactly what it is and how to avoid it. Let us begin. I want to tell you about a man named Robert. Robert was 67 years old, a retired electrician living in Ohio. He owned his home outright, no mortgage. He had a modest pension, his monthly Social Security payment, and a small savings account he had built over the years. Robert considered himself a responsible man. He had told his 2 adult children, David and Karen, exactly what he wanted to happen when he was gone. The house would go to Karen because she lived nearby and could care for it. David would receive the savings account. Straightforward. Fair. He laid all of this out over Thanksgiving dinner in 2023. Everyone nodded, everyone agreed, but Robert never put a single word of it in writing. He never signed a will. He never filed a power of attorney. He never established a transfer on death deed. He figured the children already knew what he wanted, and that was sufficient. Then, in early 2025, Robert had a serious fall. He struck his head and developed a brain bleed that left him unable to make decisions for himself. Karen went to his bank to cover his property taxes. She was turned away at the door. She contacted Social Security to manage his incoming benefits. They informed her she had no legal authority to do so. She attempted to arrange repairs to the home so Robert could return from rehabilitation, and discovered she could not sign contracts on his behalf either. Meanwhile, David hired an attorney and petitioned the court for formal guardianship. And just like that, Karen and David were no longer aligned. The court stepped in. Legal fees began accumulating. Robert's home sat empty for 11 months. Property taxes went unpaid. A lien was placed against the property. 11 months. No legal authority. No plan. A home that was nearly lost. Every single piece of that nightmare could have been prevented if Robert had filed 5 documents. Let me show you what those documents are. Document number 1, the Durable Financial Power of Attorney. This is the single most important legal document for any homeowner over the age of 60. A durable financial power of attorney grants someone you trust, a person the law refers to as your agent, the legal authority to make financial decisions on your behalf if you become incapacitated. That includes paying your mortgage, managing your bank accounts, handling your property taxes, and even selling your home if that becomes necessary. Pay close attention to the word durable. According to the Consumer Financial Protection Bureau, a standard power of attorney actually stops functioning the moment you become incapacitated. That is the precise moment when you need it most. A durable power of attorney remains in effect even after you lose the capacity to make your own decisions. Here is the trap that catches most people completely off guard. The majority of seniors believe that their spouse or an adult child can automatically step in to manage their finances. The Consumer Financial Protection Bureau is unambiguous on this point. That belief is incorrect. Without a valid, durable power of attorney, no family member holds legal authority to act on your behalf. Not your husband, not your wife, not your son or daughter. Without it, your family is left with only one available path: petitioning a court for guardianship or conservatorship. The CFPB describes this process as lengthy, expensive, and very public. ARP has documented that conservatorship proceedings frequently generate family conflict, produce competing legal petitions, and result in a court, not your family, making the decisions that govern your life. One additional point that carries real importance. The Social Security Administration now offers something called the Advanced Designation of Representative Payee. This allows you to identify up to 3 individuals who could manage your Social Security benefits in the event you become unable to do so yourself. You can complete this designation right now through your My Social Security account online at ssa.gov. I want to encourage you to do that today, not at some later point, but today. Document number 2. A last will and testament with specific provisions for your home. Now let us talk about your will. Not just any will, one that directly and specifically addresses what is going to happen to your home. According to the Consumer Financial Protection Bureau's official guide for older Americans, a will is the legal instrument that establishes your intentions for your property when you pass away, including your home. Here is where the misunderstanding runs deepest. A significant number of seniors genuinely believe that communicating their wishes to their family is legally sufficient. It is not. Without a valid written will bearing your signature, your home passes according to your state's intestacy laws. That means the state, not you, determines who inherits your property, and the formula your state uses may direct your home to individuals you never intended to receive it. AARP states this plainly. Without a will, the outcome is determined by state law and probate courts, which creates unnecessary time delays and financial expense. This can produce what AARP describes as tangled titles, situations where the person occupying the home is not listed as its legal owner. That person cannot sell the property, they cannot refinance it, they cannot obtain proper insurance coverage. In certain cases, they cannot authorize even the most basic repairs. And the financial cost is real. AARP estimates that navigating probate without a will can consume more than a full year and cost upward of 3% of the estate's total value. On a home and estate worth $1 million, your heirs could forfeit over $30,000 in probate expenses alone. If you are over 60 and you own your home, you need a will. And if you already have one, take it out and look at the date it was signed. If it was written before a significant life event, a divorce, the death of a family member, the arrival of grandchildren, it very likely needs to be revisited and updated. Free legal assistance is available for people over 60 through the Elder Care Locator. That number is 1-800-677-1116. Document number 3. A transfer on death deed or a revocable living trust. This is the document most seniors have never encountered, and it may be the most powerful one on this entire list. A transfer on death deed, often referred to as a Todd deed, is a legal document stating that when you pass away, your home transfers directly to the person you have named. No probate, no courtroom, no extended waiting period. According to the Consumer Financial Protection Bureau, It is simpler to create and less expensive to establish than a trust. As of 2026, approximately 30 states, along with the District of Columbia and the U.S. Virgin Islands, permit transfer on death deeds. You file it with your local recorder of deeds office. You retain full control of your home for the remainder of your life, and you can modify or cancel the deed at any time. If your state does not permit transfer on death deeds, the appropriate alternative is a revocable living trust. According to consumerfinance.gov, a living trust allows you to transfer your home into a trust that you yourself control during your lifetime. You serve as your own trustee. When you pass away or become incapacitated, a successor trustee you have already designated steps in, without any probate process whatsoever. But here is a critical mistake that catches people who have taken this step. Many people establish a living trust and assume the work is finished. It is not. The Consumer Financial Protection Bureau is very specific on this point. A living trust accomplishes nothing until property is physically transferred into it. That means you must retitle your home in the name of the trust. If you skip that step, your home still travels through probate, even though you paid an attorney to create the trust in the first place. The CFPB also issues a clear warning. Trusts are sometimes marketed by dishonest individuals and firms targeting seniors. If anyone approaches you unsolicited offering to establish a trust on your behalf, verify their credentials carefully and consult an independent attorney before proceeding. One more element that is absolutely essential to understand. According to Medicaid.gov, state Medicaid programs are required under federal law to pursue recovery of payments from the estates of individuals aged 55 and older for nursing facility and home care services provided. States may even place liens against your home during your lifetime if you are permanently institutionalized. However, and this exception carries enormous significance, states are prohibited from pursuing estate recovery if you are survived by a spouse, a child under the age of 21, or a child who is blind or disabled regardless of age. Understanding these rules thoroughly before making any transfer decisions involving your home is not optional. It is essential. Document number 4. An Advanced Healthcare Directive. This is the document that protects your body and your medical wishes, not just your bank account. According to Medicare.gov, an Advanced Healthcare Directive contains 2 distinct components. The first is a healthcare proxy, sometimes referred to as a durable power of attorney for healthcare. This designates someone you trust to make medical decisions on your behalf if you are unable to speak for yourself. The second component is a living will. This document records which medical treatments and interventions you want, or specifically do not want, if your life is in jeopardy. That includes decisions about dialysis, mechanical ventilation, resuscitation, and feeding tubes. It also captures your preferences regarding organ or tissue donation. Here is a misconception that costs people dearly. Many seniors assume their financial power of attorney also covers medical decision-making. It does not. The Consumer Financial Protection Bureau makes this distinction absolutely clear. A financial power of attorney and a healthcare directive are 2 entirely separate legal documents. You need both. And here is a second mistake that undermines the directive even after it has been created. People complete the document and then place it in a filing cabinet without telling anyone where it is. If no one can locate your directive during a medical emergency, it provides no protection whatsoever. You must give copies to your physician, your hospital, your designated healthcare proxy, and at least one additional trusted family member. There is meaningful good news here. Medicare covers advanced care planning conversations at no cost to you when the discussion takes place during your annual wellness visit. The next time you attend that yearly appointment, raise this topic with your doctor. Ask for their assistance in documenting your wishes formally. You are fully entitled to do so. Medicare.gov states explicitly that you have the right to carry out your plans as you have chosen without discrimination of any kind. AARP has documented that the absence of a healthcare directive is one of the primary drivers of conservatorship proceedings that tear families apart. Do not leave your family in that position. Document number 5. Your homestead exemption and senior property tax exemption application. This is the document that saves you real money every single year. And it contains the hidden tax trap I promised to reveal at the beginning of this video. Most states and many local governments offer homestead exemptions or senior property tax exemptions. These programs reduce the assessed taxable value of your home, which directly lowers your annual property tax bill. Some states go further and offer tax freeze programs that place a ceiling on how much your property taxes can increase from year to year. Here is what catches people completely unprepared. These exemptions do not apply automatically. AARP is very direct about this. You must submit a formal application to your local county assessor or tax authority, and in many jurisdictions, the application must be renewed annually or on a periodic basis. AARP quotes a subject matter expert who puts it plainly: anyone can forget to complete the renewal notice, particularly older adults who are managing large amounts of incoming correspondence. Miss the filing deadline and you pay the full unexempted rate. Over 10 or 20 years of retirement, that oversight can accumulate into tens of thousands of dollars in completely avoidable expense. On the federal level, the IRS now provides Form 1040 SR, a tax return specifically designed for seniors with larger, more legible print. And beginning with the 2025 tax year, there is a new enhanced standard deduction available to taxpayers who are 65 and older. According to IRS Publication 554, if you are considering the sale of your primary residence, you may be eligible to exclude up to $250,000 in capital gains from the sale, $500,000 for married couples filing jointly, provided the home served as your primary residence for at least 2 of the preceding 5 years. That comes directly from IRS Publication 523. Now, here is the hidden tax trap I warned you about at the very beginning of this video. This is the one that carries the greatest financial consequences for your family. If you deed your home to your child as a gift while you are still living, your child receives your original cost basis in the property. Let me translate that into real numbers. Suppose you purchased your home 40 years ago for $50,000. Today that home is valued at $400,000. If you gift it to your son, his cost basis in the property is $50,000. When he eventually sells that home, he will owe capital gains tax on $350,000 of recognized gain. But if you retain ownership of the home and he inherits it following your passing, something fundamentally different occurs. Under IRS Section 1014, the cost basis steps up to the fair market value of the property on the date of your death. His basis becomes $400,000. If he sells the home for $400,000, he owes 0 in capital gains taxes. Not a reduced amount, 0. That single decision, whether to gift the property or allow it to transfer through inheritance, could represent the difference between your child preserving their financial security and surrendering a massive portion of it to federal taxes. This information comes directly from IRS Publication 551 and the IRS Gifts and Inheritances FAQ page. Please consult a qualified tax professional before transferring your home to any other person under any circumstances. You now know all 5 documents, but knowledge that produces no action changes nothing. So here are 3 concrete steps I want you to take this week. Not at some point next month, not eventually. This week. Step 1. Gather your 5 documents and identify your gaps. Sit down at your kitchen table with a pen and a piece of paper. Go through the complete list. Check off every document you already have in place. Circle every one that is missing. The list is as follows: a durable financial power of attorney, a last will and testament with specific instructions for your home, a transfer on death deed or a revocable living trust, an advanced healthcare directive that includes both a living will and a designated healthcare proxy, and your homestead or senior property tax exemption application. If even a single document on that list is absent, you have a gap, and gaps are what cost families their homes, their savings, and the peace they worked decades to earn. For any documents you need assistance creating, contact the Elder Care Locator at 1-800-677-11116. This is a free government-funded service available to all Americans over the age of 60. They will connect you at no charge with qualified legal assistance in your local area. That number one more time, 1-800-677-1116. Step 2. Place your documents in the hands of the people who need them. Filing a document and placing it inside a drawer is not a plan. It is a starting point. Your durable power of attorney needs to be formally on file with your bank and any financial institution you use before an emergency situation arises. The Consumer Financial Protection Bureau specifically warns that many banks will reject a power of attorney document they have never previously reviewed. Do not discover that limitation in the middle of a crisis. Your advanced healthcare directive needs to be physically in the possession of your physician, your hospital of record, your healthcare proxy, and at least one additional trusted family member. And while you are taking these steps, log into your My Social Security account at ssa.gov and complete your advanced designation of representative payee. Name up to 3 individuals you trust implicitly. This costs nothing, it requires only a few minutes, and it has the potential to prevent an enormous amount of chaos and heartbreak. Step 3. Review and update everything on an annual basis. Life changes. Relationships evolve. Laws are revised. The person you named as your agent 5 years ago may no longer be the appropriate choice today. A will written before a divorce may direct your home to someone you never intend to receive it. Choose a specific date each year, perhaps your birthday, perhaps the first day of January, and use it as your annual review appointment with yourself. Confirm that every document still reflects your current intentions. Verify that the right people still hold current copies. Confirm that your property tax exemption has been properly renewed. That single annual habit may be the most consequential thing you do to protect everything you have built. Before I let you go, I want to say something that matters deeply. Everything I walked you through in this video has the potential to change the trajectory of your retirement. It can protect your home. It can spare your family from courtroom battles, unexpected tax burdens, and financial devastation that should never have happened. But here is the reality you need to sit with. The government is not going to send you a reminder to file these documents. There is no notification that appears on your phone when a relevant law changes. And relying on the algorithm to surface the right information at the right moment is not a plan you can depend on. This channel exists to make sure you are never caught unprepared. We send real-time alerts whenever there is a meaningful change to Social Security rules, Medicare policies, pension regulations, banking laws, insurance standards, or any financial matter that directly affects seniors. No unwanted messages, no advertisements, only clear, verified, timely information delivered directly to you so that you are always ahead of what is coming. Click the link in the description right now. Subscribe to the channel, download your complimentary guide, and share this video with someone you care about who owns their home and is over the age of 60. Because the 5 documents we covered today carry only one condition for them to actually work. They must be filed before the crisis arrives, not after. I am June. Thank you for spending this time with me today. I will see you in the next video. Stay safe, stay informed, and protect everything you have worked your entire life to build.